All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We're here in our case 1-ACV 21-0007, Lou versus New Rez. Each side will have 20 minutes to present their argument. Opponent, you may reserve any amount of that time for rebuttal, but you'll have to keep track of the time yourself. We have a clock at the podium, so you can keep track of the time. Because you're arguing from your table, you're welcome to walk around and to observe the clock. We are recording the argument both in audio and video, so when it's your turn, please identify yourself and your client so that we can keep everybody straight when we review the argument later. The video will be on YouTube in a couple of days if you want to revisit how you did today. We've read the briefs, we've looked at the record, we've conferenced the case, so we're familiar with the issues. So when you begin the argument, just start right out with what you would like for us to know. Counsel, you may begin.
Thank you, Your Honors. My name is Lawrence Hirsch. I represent the appellant Gwynn and Lou. The issue is pretty straightforward. It's how does a bankruptcy discharge impact the statute of limitations to commence a foreclosure under Arizona law? I would suggest to the court that this is basically a three-step approach that combines both state and federal law. The first step is to determine what law to look at, first in determining the impact of a discharge on a foreclosure or on a statute of limitations. The Stewart versus Underwood case tells us that we look to bankruptcy law to first determine the impact of the discharge and of the bankruptcy on the matters before the state court. We then look to the Ninth Circuit Court decisions in Hernandez and Jarvis that tell us that the impact of a discharge is to act as a maturation of the note because no payments are due any longer after the entry of the discharge.
But the maturation of the note and all that seems to me to be a matter of state law. Why would we look to the Ninth Circuit on that?
No, you look to state law to determine how does that impact the statute of limitations. Federal law determines the impact of the discharge. The discharge acts as a maturation of the note because under the definition of what's due and owing implies that there must be an obligation that remains due in order for a payment to be due. It's not simply the passage of time like a train is due in 10 minutes to arrive at the station. A payment is due, it means that there is an obligation that has matured and is enforceable. That's how Black's Law Dictionary defines due. So you have to look to the bankruptcy code and to federal law to determine how the bankruptcy treats the note.
But I thought bankruptcy law, I never practiced bankruptcy, so correct me if I mistake something, but I thought bankruptcy was a personal thing that when you discharge in bankruptcy, that prevents the creditor from personally coming after you for that debt. That doesn't mean that the debt doesn't exist. It just means that the creditor can't collect that debt against you. If there is property out there that is
Yes. The bankruptcy
go against that.
The bankruptcy discharge is an in personam remedy. However, it means that there is no longer a payment due. Now, where the Stewart Court stopped its analysis was simply saying that the homeowner in Stewart, the plaintiff in that case and the appellee, had argued that the bankruptcy discharge voided the lien. And of course it doesn't. We all agree that the bankruptcy discharge doesn't void the lien. And you point out the creditor still has its in-rem remedies even after the entry of the discharge. That's as far as Stewart goes. We now have to analyze, does the discharge impact the creditor's obligations to enforce its in-rem remedy? And that's where we say yes, that the impact of the discharge is to act as a maturation of the note because there is no longer a payment due. That's what the Ninth Circuit has said in several cases as well.
Counsel, other than Washington law, because that's the only thing that the Ninth Circuit is relying upon, in my view, or from my reading of the cases, they're relying on the one case that's arguably, perhaps even more than arguably, dicta out of Edmondson. What else do you have besides Edmondson?
It's not just Edmondson, because Edmondson relies on Silvers, which was a year prior to Edmondson, and Silvers says the same thing. Silvers, and again, Edmondson, Silvers, and Stewart all had the same predicate facts, where a lawsuit was brought within 6 years after the entry of the discharge to try to void a lien. And in all three of those cases, the court rightly ruled that because the discharge had been entered less than 6 years before the filing of the lawsuit, that the statute of limitations hadn't run. However, all of those cases point out that the discharge triggers the onset of the statute of limitations because there's no longer a payment due. So it's not just Edmondson, it's Silvers, Edmondson, and then if you look at the Love case, which was just a recent decision of the Washington courts, it traces at least another half a dozen Washington cases. Now, I will acknowledge to you that the only law that any of us have been able to find on this issue is Washington law. But Washington law is almost identical to Arizona law in a number of factors. First of all, they both have the same position as to the statute of limitations on an installment note. Navy Federal Credit Union tells us that each unpaid installment triggers its own statute of limitations for the unpaid payment. The Herzog case in Washington says the same thing. Each unpaid payment on an installment note triggers its own statute of limitations. The Silvers case and the Edmondson case, and then the cases that have followed in Washington since, including Hernandez and Jarvis, all point out that once the discharge is entered, there is no longer a payment that is due because the obligation to pay has been eliminated by the discharge. Now, it doesn't void the lien. I understand it doesn't void the lien, but it does trigger the limitation period.
Counsel, correct me if I'm wrong, but the effect of a discharge does not eliminate debt. Isn't that correct?
It doesn't eliminate the debt, but it creates a maturation of the loan because there's no longer an obligation to pay.
Okay, so let's head back here. So the effect of a discharge is governed by statute. You'd agree with me on that?
The effect of the discharge is covered by statute, yes.
Particularly the description of a discharge under 11 U.S.C. 524. Okay, that's the discharge section, okay? So, and that, what it says there specifically in that statute, specifically in subsection A2, is that the effect of a discharge is as an injunction against a personal collection of the debt.
It acts as an injunction.
An injunction.
It acts as an injunction.
Right. So as to personal collection of the debt.
So you can no longer enforce the debt.
Personally.
You can no longer enforce the debt.
Personally.
You can no longer enforce the debt, yes.
Okay, so, counsel, sorry to interrupt, but when you're conducting a trustee sale, what do you calculate that on? Thin air?
I'm sorry.
When you foreclose on the collateral, you have to come up with an amount. Isn't that based on the note?
It is based on,
So it is running. The debt is running, and it is accruing interest if there's interest provided for. How does it go away?
It doesn't go away. The effect of the discharge as set forth in the cases we've cited is that it triggers the statute of limitations. And let me quote from the Hernandez case. The statute of limitations does not continue to accrue after discharge because at that point installment payments are no longer due. That's from the Ninth Circuit. Now, the Arizona Supreme Court...
Counsel, that's the Ninth Circuit clearly applying Washington law.
It's applying a combination of Washington law and the bankruptcy code. Like I said, it's a three-part step. As Stewart said, you first have to look to the bankruptcy code to determine what is the impact of the bankruptcy of the discharge on an obligation. You then look at the Ninth Circuit decisions, which say that the impact of the discharge is to act as a maturation of the note. And again, this is from the Jarvis case. The last payment owed commences the final 6-year period to enforce a deed of trust securing a loan. This situation occurs when the final payment becomes due, such as when the note matures or a lender unequivocally accelerates the note's maturation. It also occurs that the payment owed immediately prior to the discharge of the borrower's personal liability in bankruptcy, because after discharge, a borrower no longer has forthcoming installments that he must pay. That's an interpretation of the bankruptcy code. Now,
That's an interpretation of Washington law.
but it's also identical to Arizona law. But
Is it?
yes,
My understanding is that Washington did not have the benefit of, say, the Brown versus Nolan case in 1977, which said that acceleration is a remedy exercisable only at a lender's option.
yes, Washington
So how
also...
is a lender acting in a bankruptcy?
But it only applies to a note that is not fully due. There's no Arizona law that says that a fully matured note has to be accelerated because there's nothing to accelerate anymore. Once the note is fully matured, there's no requirement for an active acceleration. It would be a redundancy.
But you just agreed that the discharge does not dispose of a debt under the bankruptcy statutes.
But it acts as a maturation of the note for the purpose of triggering the statute of limitations to start the foreclosure.
How can it do that under... I'm sorry.
No, I'm sorry.
No, please.
How can it do that under Brown v. Nolan?
Because
How is that an action of a lender?
I'm willing to bet that in that case it was an unmatured note, and the lender has the right to accelerate. Again, the Hernandez case makes the same comment, that the Hernandez bankruptcy court had said that the creditor succeeded because it did not take an act of acceleration. In reversing it, the district court said it didn't have to, there was no requirement for an act of acceleration because the note was deemed to be fully matured. The laws are the same. Washington law also recognizes that a lender has to accelerate in order to have unpaid installments come due. Now, it's interesting that that line of cases in Arizona arises out of Navy Federal Credit Union, which was an unsecured promissory note. The Arizona foreclosure statute contains its own, in effect, acceleration clause in Title 33 when it says that upon a trustee sale, all unpaid principal gets paid. So in reality in Arizona, an acceleration is somewhat of a redundancy on a deed of trust because if they don't accelerate and they go to trustee sale, they just don't get paid the unpaid past due payments, they get paid the entire balance due under the note. So there's really no requirement that a creditor accelerate. It's somewhat of an empty act that simply allows a creditor to sit back and say, well, we didn't accelerate, so the statute of limitations doesn't run for us. But both Washington and Arizona law recognize that in a non-bankruptcy context, a creditor has to accelerate in order to trigger the limitation period for future unpaid payments. When the bankruptcy court in Hernandez ruled against the homeowner and against the debtor, because of that, it got appealed and it got reversed, because there was no requirement for an active acceleration on what's deemed to be a fully matured note.
Counsel, I'm still having difficulty separating what is properly bankruptcy law and what is what is Arizona or state law. As I understand it, the bankruptcy statute, as you said, that a discharge acts as an injunction that prevents the creditor from getting payment from the debtor. But whether a note is accelerated or matures, that seems to me to be a matter of state law that bankruptcy necessarily doesn't speak to. So I'm confused about that.
The issue of state law is once a note is deemed to be matured, does the statute of limitations start to run on that note, on that obligation, on that right to foreclose?
And it seems like state law determines when a note is matured or not.
I would disagree, Your Honor. I think that is the bankruptcy code tells us that because there's no longer a payment that is due, and remember, I've tried to make this point a few times and I've been asked questions, both Navy Federal Credit Union and Herzog, Navy Federal Credit Union being the Arizona case on installment notes and acceleration, and Herzog, which is the Washington case on installment notes and acceleration, say the same thing, that the statute of limitations begins to run on each payment as it becomes due. That is when the creditor has a right to enforce the obligation to pay. That's how both states define due under an installment note. When the payment comes due and when the creditor has the right to demand performance. Since the creditor doesn't have a right to demand performance of the note once the discharge is entered, the last time that there was an obligation to pay was the last payment due before discharge. So now you have what's deemed to be a matured note, where there's no obligation to pay. Now you look to state law to say, okay, under state law, if there's no longer an obligation to pay, when does the statute of limitations start to run? I think under Navy Federal Credit Union, it would start to run when the last payment was due. The last payment was due the month before the discharge was entered, because once the discharge is entered, there's no longer an obligation to pay. There's no longer a payment that comes due.
Counsel, you just said that there's no longer an obligation.
There's no longer an obligation to pay.
No, what you just said was that there was no longer an obligation. Do you agree that bankruptcy has absolutely zero impact on security interests?
Well, that's probably an oversimplification, but a lien survives a discharge. There are circumstances in bankruptcy where a lien can be voided.
Well, aside from avoidance, okay,
a lien would survive a discharge, and that's what Stewart says, and we agree with that a lien survives a bankruptcy discharge.
A valid perfected lien is unaffected by bankruptcy.
Again, other than certain avoidance rights, but yes, I understand what you're saying. A valid perfected lien survives a bankruptcy. It doesn't mean that a statute of limitations to enforce that lien hasn't been triggered by the discharge. That's the distinction. The lien survives, and that's what the court said to Stewart, and I agree with that. The lien survives the bankruptcy. In the Stewart case, the homeowner had filed a lawsuit, I think a year and a half or 2 years after the discharge, claiming that the lien was voided by the bankruptcy. The Stewart court said, no, it's not. That's the holding of Stewart, that the lien survives the bankruptcy and it is not impacted by the discharge. It doesn't mean that the statute of limitations to enforce that lien hasn't commenced because there's no longer a payment that is due. Under Navy Federal Credit Union, a cause of action accrues whenever one person may sue another. Most courts have addressed the issue, rule that the action accrues and the statute of limitations runs against each installment for the time it becomes due. If nothing is due, to go back to the law dictionary about the definition of due, a debt or claim in question is now matured and enforceable, owed or owing as distinguished from payable. It implies that there is a consequence for non-payment. If there's no longer a consequence for non-payment, the statute of limitations is triggered. In Jarvis,
Is there not a consequence for non-payment under a security arrangement?
yeah, and they've got 5 years, and they've got 6 years to enforce that. That's the point, is that once the discharge is entered and a payment isn't made, that triggered, the limitation period has now been triggered because there's no longer a payment that's due. That was their time to commence the foreclosure within the 6-year period after the payment that was due immediately prior to the discharge. That's correct, that's our point.
After an acceleration occurs?
There's no requirement to accelerate a fully matured note. And if the loan is treated as mature, and again, let me quote from the Jarvis decision. The last payment owed commences the final 6-year period to enforce a deed of trust securing a loan. This situation occurs when the final payment becomes due, such as when the note matures, or if the lender unequivocally accelerates the note's maturation. It also occurs at the payment owed immediately prior to the discharge of a borrower's personal liability in bankruptcy, because after discharge, a borrower no longer has forthcoming installments that he must pay. That's our position.
Counsel, you just over a minute remaining. Do you want to save any time for rebuttal?
I've got a minute left. I guess I'll save the minute, but thank you.
Thank you, counsel.
May it please the Court. Aaron Edwards for Mortgage Electronic Registration Systems, Inc., commonly known as MERS, and Rez LLC, doing business as Shell Point Mortgage Servicing. In this appeal, Mr. Wynn and Ms. Liu are trying to turn a bankruptcy discharge into something that it isn't. They want this court to hold that Mr. Wynn's discharge effectively made it so that his loan is no longer due and that installment payments are no longer due, that his debt is effectively extinguished. They argue this because of the poorly reasoned decision in the Washington State Court of Appeals, the Edmondson versus Bank of America case, that holds that the statute of limitations for installment debt only accrues until the borrower no longer has personal liability on the underlying note. According to Edmondson, once the borrower discharges his personal liability, the statute of limitations to foreclose the deed of trust that secures the loan is triggered and starts to run. So
Whether that opinion is correctly or poorly reasoned, do we really care what Washington says on this issue?
No, we do not. We don't care about what Washington says on this issue for 2 reasons. First, it's applying Washington state law only. And second, because Arizona already has laws on the books that address this issue. The Jarvis, Hernandez, and Love case, they're all unpublished. And Jarvis and Hernandez, they're Ninth Circuit, but they are interpreting solely Washington state statute of limitations law, which does not apply to Arizona state statute of limitations law. And in Edmondson, the court essentially cited nothing for its determination that a bankruptcy discharge triggers the final statute of limitations period to foreclose. It simply determined that no payments are due after a bankruptcy discharge. But this court already held long ago in Stewart versus Underwood that a bankruptcy does not extinguish the debt. The only thing that a bankruptcy discharge does is it prevents the lender from pursuing a breach of contract action against the borrower personally for not paying that debt. Both the debt itself and the lien that secures the debt survives a bankruptcy.
So, counsel, that means that the ability to proceed in rem is not affected by the discharge. Is that what you're implying?
That's absolutely correct.
Okay.
That's correct. And
But counsel, but the debtors still, I mean, they're not can't be said that they have an obligation to pay the debt.
they don't have an obligation to pay the debt. But
So what's wrong with the argument that it does trigger, because, I mean, the obligation ends at discharge? What's wrong with that argument?
Well, actually, I would like to clarify my position that the obligation still exists. There could still be a moral obligation to pay it. The debt is still due, and it's still due in installments. And even the Inree Berry case that Stewart cites in its opinion says that a debt is still rightfully due after a discharge. And the homeowner could even pay the debt monthly, month by month, according to the terms of the note after a discharge and stave off foreclosure in that instance. Borrowers do that all the time despite receiving a discharge. If they want to avoid foreclosure, they can keep paying that debt according to the monthly installments that are due under the note and deed of trust.
And it's all a matter of state law. It's nothing to do with bankruptcy law.
That's correct. The bankruptcy law only says what the effect of the discharge is on being able to pursue the borrower personally. Stewart versus Underwood recognizes this, that the discharge only prevents a personal action, that the lien survives and the debt survives. Stewart says both of these things. And this court's already determined what happens to the statute of limitations when it starts to accrue for unextinguished installment debt. The court looks to the plain terms of the note and the deed of trust, not to the borrower's personal liability. That's because the statute of limitations in Arizona for installment debt is tied to contract principles. A breach of contract cause of action is triggered when when the contracting party breaches the contract. For an installment contract, the borrower doesn't breach their obligation to pay an installment until that installment comes due without a payment. And this is true regardless of whether or not the lender can still sue the borrower personally under that contract. As Stewart pointed out, the statute of limitations for the contract action is tied to the statute of limitations for the foreclosure action. The period for an action in rem is tied to the period for the action on the contract under ARS 33-816. That's regardless of whether or not the lender can pursue the borrower personally. Stewart, in fact, says there's no indication that our legislature intended to create some type of sliding scale in which enforcement of the lien is precluded if some fortuitous circumstance prevents an action on the contract. So if a future installment date hasn't lapsed yet, it's still due after bankruptcy discharge, the statute of limitations period could not have been triggered. It's also important to note that neither Darvis, Edmondson, or Hernandez actually said that the loan is matured because of a bankruptcy discharge. In fact, Edmondson said that the loan in that case had not been accelerated. The maturity date had not been accelerated despite the bankruptcy discharge. That's because in Arizona, there's only one way to trigger the final statute of limitations period before the debt has fully matured. That's through lender acceleration. Lender acceleration only occurs when the lender makes an affirmative act to make clear to the debtor that it has accelerated the debt. And
what are a couple examples, or what are some examples? How do you accelerate the debt?
You can accelerate the debt by by telling the borrower in a letter and some written correspondence that the debt's been accelerated, by saying that the full debt amount is immediately due and payable, that by proceeding with foreclosure, by filing a foreclosure action, which you can do judicially. All of those actions, by repossessing a vehicle, all of those actions constitute affirmative lender actions. But a bankruptcy discharge or any actions in a bankruptcy, that's not a lender action. That is a borrower in court action. And the only way to trigger the optional acceleration provision in the note and deed of trust is through an affirmative lender action.
So it's a filing of a notice of foreclosure. Is that an acceleration of the debt?
That is actually, this court recently held that filing or recording a notice of foreclosure in and of itself is not a sufficient act to accelerate the debt. That was in the Lavelle Bridges versus Nation Star mortgage matter. That's currently on appeal before the Arizona Supreme Court. But it actually, the notice of foreclosure sale would need to say something more than just the foreclosure sale is being scheduled. It would need to make clear to the debtor that the lender has accelerated the debt, because under ARS 33-813, the foreclosure sale can be scheduled without the debt being fully accelerated. So the only way to trigger the final statute of limitations period to foreclose in Arizona is either through the debt becoming fully matured according to the plain note and deed of trust terms, or through affirmative lender acceleration. Neither occurred here because First, the deed of trust and the loan doesn't mature until 2031, and Mr. Nguyen and Ms. Liu did not allege that the lender affirmatively accelerated through any actions. So the court correctly dismissed the complaint because there is no cause of action that can be based on expiration of the statute of limitations. And since I do have a little time left, I wanted to address a couple of things that were raised in Mr. Nguyen and Ms. Liu's reply brief, specifically that MERS and Shell Point waived certain arguments because they weren't raised in the answer brief. The first being that acceleration is meaningless after a discharge. That absolutely was addressed in the heart of what we're arguing here today. Because the loan still becomes due after a bankruptcy discharge, it's still rightfully due according to Stewart in the Inree Berry case that it cites, and it continues to become due as an installment debt. The lender absolutely would need to accelerate those payments and can accelerate those payments. That was argued in our brief. And also reaffirmation and acknowledgement. Those arguments really don't need to be addressed because we're not talking about a situation where the lender is trying to go after the borrowers personally for not paying their debt. We're talking about the lender retaining its right to foreclose under the deed of trust that survived a bankruptcy. Reaffirmation and acknowledgement isn't necessary for the lender to do that. Thank you, Your Honors.
Thank you, counsel.
Thank you, counsel.
Counsel?
Thank you, Your Honors. Again, Lawrence Hirsch. I have about a minute left. Two short notes. First of all, the Ninth Circuit, in the Jarvis case, does say the following: the discharge of a borrower's personal liability on his loan, the cessation of his installment obligations, is the analog to a note's maturation. In both cases, no more payments could become due. So the Ninth Circuit has said that a discharge acts as a maturation of a note. In the Rudd case, the court, and again referring to Edmondson, states that the Edmondson court based its reasoning on settled law granted from Washington, with the Washington Supreme Court holding that when recovery is sought on an obligation payable by installments, the statute of limitations runs against each installment from the time it becomes due. That is, from the time when an action might be brought to recover it. That's the exact same language as the Arizona Supreme Court used in Navy Federal Credit Union to explain when the statute of limitation runs on an unpaid payment. And I'm done.
Thank you, counsel. We appreciate your arguments today. We'll take this matter under advisement and issue a decision in due course. We're going to stand at recess for the next case, but we're going to remain along the bench in the meantime. Thank you very much.
Thank you for your time, Your Honors.
Thank you,
I
Your
hope
Honors.
everyone stays well and healthy.
Thank you.